Good afternoon, class. Today we're going to talk about the Sixth Amendment rights of the accused in criminal prosecutions. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial and public trial by an impartial jury of the state and district where the crime shall be committed, which district shall all previously asserted by law and to be formed of the nature cause of the accusation, to be confronted with the witness against him, to have compulsory process to obtain witness in his favor, and to have the assistance of counsel for his defense. Basically, it means the right to have a fair trial and a fair counsel. The beginning of it really begins when our founding fathers came by. At the time of the founding, there were local sheriffs, but no professionalized police forces. Instead, ordinary men took turns serving as constables and the night watchmen. Criminal cases were almost always brought by the victims, not public prosecutors. At trial, neither side typically had a lawyer, but both victims and defendants represented themselves. Trials were like shouting matches in which victims and defendants argued over and brought over live witnesses to tell their stories. It usually didn't last that long. Juries of 12 ordinary men were central players in the system. There were local citizens who often knew the victim, defendant, or the people and places involved. They also knew which charges subjected defendants to the death penalty. As many felons did, which did not, jurors looked witnesses in the eye and debated both whether a defendant was factually guilty or deserved some sort of mercy. They checked the government's power to punish and applied the conscience of the community in the public eye, ensuring everyone that justice had been done swiftly, impartially, and fairly. The framers of the Sixth Amendment sought to straighten this vigorous adversary process. Continental Europe had long used a system like this, in which magistrates investigate crimes and judges taking lead roles in framing the issues, digging up evidence, questioning witnesses, basically gathering all the evidence. The Anglo-American system, the Sixth Amendment, provided, by contrast, leaves it to which side to conduct his own investigation, present its own evidence, and argue one side of the story in open court. Most of the institutions of the criminal justice changed greatly over the decades after the Sixth Amendment was enacted. Professional police forces came into being and took charge investigating the crimes and arresting subjects. Public prosecutors steadily displaced victims and then defendants who could afford to increasingly hire lawyers to level the playing field. In some communities, charities, and local governments set up public defender offices, offering free lawyers to all or some defendants accused of serious crimes, basically. Judges developed rules, evidence, and procedure and gave lawyers a say in selecting and instructing juries, so trials grew longer and more complex. To avoid the time and expense of the jury trials and clear courts, busy dockets and prosecutors, defense lawyers also increasingly plead bargains. That meant that most defendants avoided trial and pleaded guilty in exchange for lower charges and sentences. So by the mid-20th century, juries resolved only a fraction of criminal justice cases. And then as difficult for the court, in addition, people that go to court may not be able to pay for counsel either. That's why I discussed before the case of Gideon versus Wade Wright, because without it, that went to court would not be fair trial and fair to counsel as well. So modern application. So back in 2008 or so, Karen Davis was 22 when he was charged with capital murder and booked into county jail. 10 years later, he was still there awaiting trial. He's had 2 judges, 4 teams of lawyers, and 9 trial dates. The first which is in 2008. His case has outlasted a district attorney who served for nearly 3 decades. Defines any common understanding of the right to a speedy trial. As the case has languished, Mr. Davis, whose only prior offense was driving without a license, has been segregated from the jail's general population for minor transactions like unauthorized peanut butter, jelly sandwiches, and a couple more serious ones, like fighting. Basically, the case of State Alabama versus Karen Torchek Davis underscores how the country's justice system can flounder at many levels, especially in poor defendants, and exposes the loopholes in constitutional protection that's supposed to use to ensure that both the victims and the accused recently time justice. In capital murder cases in which the defendant faces a death penalty, it is not unusual to spend 2 to 3 years behind bars waiting trial if the defendant is not granted bail or is unable to afford it. But a decade is extreme. Mr. Davis's wait is among the most protracted that the New York Times could find. I talked about the case summary, Gideon versus Wainwright. Okay, the trial itself represented himself. Gideon represented himself. He made an opening statement to the jury, cross-examined the prosecution witnesses, and presented witnesses in his own defense, declined to testify himself, and made arguments emphasizing his innocence. Despite his efforts, the jury found Gideon guilty and he was sentenced to 5 years in prison. Gideon sought relief from his convictions by filing a petition of right of habeas corpus in the Florida Supreme Court. In his petition, Gideon challenged his convictions and sent on the ground that the trial judges refused to appoint counsel violated Gideon's constitutional right. The Florida Supreme Court denied Gideon's petition. He handwrote a petition to the Supreme Court of the United States. The court here to hear the case to resolve the question of whether the right to counsel guaranteed under the Sixth Amendment of the Constitution applies to the defendants in the state court. A prior decision, the court's Bettis versus Brady, 316 U.S. .55 1942, held the refusal to appoint counsel for the indigent direct defendant charged with a felony in state court did not necessarily violate the due process clause of the 14th Amendment. The court granted Gideon's petition for a right of clitorio, that is, agreed to hear Gideon's case and review the decision of the lower court in order to determine whether Bettis should be reconsidered. The court held that the Sixth Amendment guarantee of counsel is a fundamental right essential to the fair trial and such as applies to the state through the due process of the clause of the 14th Amendment. In overturning Bettis, Justice Black stated that reason and reflection requires to recognize that our adversary system, the criminal justice, and any person held into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He further wrote that the noble idea of fair trials before impartial tribunals in which every defendant stands equal before the law cannot be realized if the poor man charged with the crime has faced his accusers with a lawyer to assist him. So that was the Sixth Amendment and some modern time applications and certain cases that belong with it. Thank you.